welcome to another episode here of Cressy's Ontario Landlord Series. Today, we're going to get into litigation and discussion with our friend and colleague, Gibran Maliki Sanchez from Maliki and Sanchez Law, Mississauga here. He is a lawyer that specializes in helping landlords here through their tenant issues on all different types of levels through the court system, litigation expert and friend of mine. So let's bring him in. Gibran, how are you today? What's going on?
Good, Kevin. It's great to be back on your podcast. Thanks for having me here today to discuss this topic.
So, for landlords and tenant issues here, Gideon, if it's not something that's going to be handled at the board, what are the different levels of court and situations that pertain to each level if we're in a litigation situation with a tenant?
That's a good question, Kevin. So, yes, landlords can find themselves in situations where the landlord and tenant board will not take on their matter. And there are a few other courts that can deal with that. So, I just kind of want to set the table here to see how a landlord will get themselves in that situation where they do have tenants, but the landlord and tenant board will not hear their case. So everything is governed by the Residential Tenancies Act for residential tenancies in Ontario. And at Section 183, Sub 2 of the Act, it says that the board has exclusive jurisdiction to determine all applications under this Act with respect to all matters in which jurisdiction is conferred on it by this Act. So, what we can understand from that is that the Landlord and Tenant Board only handles matters that fall within the Residential Tenancies Act. So, if your issue isn't covered by the Act, the Landlord and Tenant Board can't help, even if you're clearly the landlord. So, let me tell you about what a few of those exemptions are. And those are set out in sections 5 to 7 of the Act. And this isn't a comprehensive list, they're just a few examples. So you might be a landlord with short-term rental property for the vacationing public. You know, someone who owns an Airbnb. You could be someone who owns student residences. Um, with a few limited exceptions, those aren't covered by the act. You can be the owner of a mixed-use commercial residential where the predominant use is commercial. And the well-known one, you can be the owner of a property with a shared accommodation with the occupants where you share a bathroom or a kitchen. So those are exempt from the act. Now, even though the landlord and tenant board will not hear your case in those situations, the common issues of non payment of rent or property damage or overholding tenants still come up. So that's where these other courts come in. You should understand that the small claims court can deal with monetary issues, non payment of rent and damages. And right now, the jurisdictional limit for that is $35,000. That's how high you can sue for. But that limit is increasing to $50,000 in October 2025.
Yeah, so you had mentioned that to me the other day that that limit was going up because we're, but yes, that'll be good. That helps, right? It's an extra 15 grand for people to go after, but still got
Yeah,
to make sure there's money to go after. But that's conversation related.
yeah. So if it does go higher than that amount, then there's the Superior Court of Justice. You can claim up to any amount there. The Superior Court of Justice can also deal with claims that the landlord and tenant board could typically make orders for, like eviction type orders to get an overholding occupant out. Okay. Um, so that's really helpful to know. There's there was an amendment to the Residential Tenancies Act back in September 2021 that allows landlords to now bring claims against tenants who vacated the property for rent arrears or damages within 1 year of them moving out. Now, in the small claims court, there's a 2 year limitation period for bringing a claim. So some people might wonder, can a landlord sue one of those tenants in small claims court after the 1 year window has lapsed with the Residential Tenancies Act, since it's it no longer falls under the act? Well, the answer is no, they can't, because it still was under the exclusive jurisdiction of the Residential Tenancies Act, so it's still bound by that 1 year limitation period. Now, that will lead me into, well, what if there are issues that do fall under the Residential Tenancies Act. Can you still bring claims under the small claims court if the landlord tenant board is not going to give you the remedy that you want? Yeah, it's possible. And what the court would do in those situations is apply something called the essential character test to see what the essential character of the issue is. And the leading case on that, I'll just cite it here. It's from 2015. It's called FRAC versus Cherish Home. Okay. So if anybody ever wants to cite that in the small claims court, they can rely on that test. Some of these, yeah, some of these issues might that might bring you into the small claims court or even superior court are personal injury claims like slip and fall claims or personal injury arising from assault or claims such as defamation. There could also be other claims sort of related to the tenancy itself, like separate contracts. So let's say there's a lease agreement. Obviously, the tenant can occupy the property, but what if there is a separate contract where the landlord is paying the tenant for services, such as for landscaping or snow removal of the entire complex? Is that contract tied to the lease itself, or is that a completely separate contract?
Sure, a separate contract, right?
It could be a separate contract. So, what you can do is you can bring an application to the landlord and tenant board if you're not sure and see if they determine if they have jurisdiction on it. If they say that they don't have jurisdiction there, then you can bring it to the small claims court. It's not what we call res judicata. It's a case that already was tried on its merits. It was just determined that landlord and tenant board does not have jurisdiction, so you can bring it to the small claims court or superior court to deal with that. I've dealt with a case before where I had proceedings in both the landlord and tenant board and the superior court. A situation that could arise. It's not too common in Ontario. Very common in the U.S. Very should be more popular in Ontario. It's a rent to own agreement, where you agree to rent the property out to a tenant, and so long as they make the rental payments and pay a little bit of a premium on top for a deposit, they have the right to buy the property. And if that contract goes south, let's say you want to evict the tenant for whatever reason, personal use, that particular issue will go through the landlord and tenant board. But if the tenant wants to sue for breach of contract, that's going to be dealt with in the superior court.
What if the landlord's going after for breach of contract though? Because from what I understand about the rent to own and what I've seen and talked to some people in Ontario anyways, is that when a tenant doesn't make good on their agreement, the landlord then gets to keep the asset and all deposits and everything like that, and tenant is then evicted and has to move on to something else and losing everything from behind. Sadly, I think a couple of the people I've spoke to about this were more inclined to try to have it happen versus having the tenant actually make good and be able to take on the property. The investor liked it that most times it fell apart and they were able to recoup the deposits and move forward and found it a very lucrative investment because they were able to continue to re-rent out the same investment on another rent to own to somebody else again after collecting deposit, where it didn't always seem that it was great for the tenant, where I also heard that it can be good for both depending, I guess, on the situation and what's happening.
Absolutely. Yeah, I love talking about the strategy for those. Um, let me get into that just a little bit because I'm passionate about residential tenancies in Ontario. It's good for tenants because it allows them to get into a property and start developing equity and living in a home that they want to live in now rather than waiting until they can get the mortgage approval. So let's say you have a growing family and you're like, I could afford a house with two more bedrooms 5 to 10 years from now, but I can't wait. I have to do it now. And I really like that house and I don't want to just rent and lose all my equity. I want to build equity and buy it later. So then they can get into that arrangement. And it's really good for landlords for the reasons that you just said. It's an added security. One missed rent payment's a breach of contract and they forfeit their deposits. Um, and yeah, they could potentially be evicted under the landlord and tenant board, but most importantly, it's the financial damages that the landlord can claim in the superior court. Typically, you'd want to deal with the eviction aspect of that in the landlord and tenant board, because first of all, they are going to find that they do have exclusive jurisdiction over the tenancy itself, but the damages that will be dealt with in the superior court or small claims court, depending on how much it is. But typically, with rent to owns, that amount can get higher than $35,000 or $50,000.
Yeah, and normally you're getting a more qualified tenant too, because they're looking for something of longevity, something that their family's going to grow into, and stuff like that. And they are more committed, as they say, because they have those deposits in there. It can be good for both sides, right? As long as it's done properly, and people continue to pay.
Yeah, and they would maintain the property a lot more because they're taking ownership of it.
Yeah.
Yeah, a lot of benefits. Very popular in the U.S. Should be more popular here in Ontario. Um, so I'm going to touch on one more thing here. Different type of court that you can use when there's issues with landlord and tenants that arise, and that is using the offenses under the Residential Tenancies Act. So there's a few limited examples of tenant offenses, and those are set out in section 233. For example, if a tenant changes locks without permission and doesn't give a key to the landlord, or if they are harassing or obstructing the landlord from seeking legal relief. That's pretty broad, but that includes things such as, landlord served proper notice of entry to do a repair and the tenant denies them. So now the landlord's not able to seek their legal, remedy of trying to get in there and fix the issue. The tenant can be um, exposed to a finding that they've committed a provincial offense, which has a fine of up to $50,000 for individuals. That's set out as Section 238 of the Act. So where do you go? Like the landlord and tenant board is not going to be the one who does a finding of guilt and applies these fines against the tenants. So what a landlord has to do is file a complaint to the Rental Housing Enforcement Unit. So with our technology these days, you can Google Rental Housing Enforcement Unit, and then they have a step-by-step guide on how to do it and where to contact them. And then what happens is um, the Provincial Offenses Court will take on the case and prosecute the person under the Provincial Offenses Act. So it's a good tool to keep in mind because a lot of times landlords will file an application because a tenant is interfering with the landlord's rights or responsibilities or harassing them. So um, this is just another way of dealing with that situation. But keep in mind, if you're trying to negotiate a settlement with a tenant and try to get them to pay you some sort of compensation or to stop what they're doing, you cannot threaten them with criminal proceedings. So you can't tell them that if they agree with your offer, you're not going to file this offense. It's just something that you'll have to decide if you want to use on your own initiative or not.
Their situation, right? They're different, and this option might be better than that option, or this and that, right? It's about specific situations and understanding what options are available to you, so that you can then choose which path to go down, and hopefully try to recoup some money from whatever is going on in your property, in your situation, right?
So some takeaways, Kevin, is if you're a landlord, get informed as to whether or not the landlord and tenant board will cover your issue, or if you're in a particular situation, know if it is. That way, you can streamline what your remedy is and go to the right venue at the right time. That will save you time and that will give you a better chance of success at getting the remedy that you want. Know that there is a small claims court and superior court, but those are only reserved for very specific cases. So if you're in doubt, it's best to consult with a lawyer who has experience dealing with landlord and tenant issues at the small claims court or the superior court. Otherwise, you're going to risk that they're going to throw out your case because the small claims court lacks jurisdiction.
Well, I know that was a lot of information there for everybody about what levels of jurisdiction we can go at and what different court systems we need to take things through. So if anything's ever coming up and we have any questions, we can always reach out to Giving here at Maliki Sanchez Law. You can always refer to the RTA to see what's going on there, to see what you're going to be covered and what's not. What are the exclusions? Sorry, with everything. Any last thoughts to wrap up the day, Giving, and we'll let everybody enjoy them.
Yeah, I just hope that I brought some light onto some unknown areas that landlords might not have been familiar with, and that typically there's always an option to deal with your issue in a legal and productive way. So, thank you again so much for having me on your podcast, Kevin.
I appreciate it. Thanks so much, Giving. Thanks, everybody. We'll talk to you soon. Bye for now.
Please remember, while we are professionals, this podcast is for informational and entertainment purposes only. The advice shared may not apply to your unique situation. Always seek personalized advice from a qualified professional before making any investment decisions.
Hey, everybody. Thanks so much for joining us this week. I hope you enjoyed the episode. If you're finding it informative and useful, make sure to like, subscribe, share with a friend so that we can keep getting the information out there to Ontario landlords. And keep on joining us. We'll see you next time.